All right, come sit down for a second because I need to tell you about a guy I used to know who kept challenging people to arm wrestle him in front of a crowd, lost every single time, and then walked away telling everyone he'd actually won on a technicality. Nobody ever saw the technicality. There was no technicality. There was just a man face down on a table, insisting the table had cheated. I bring this up not because I have strong feelings about barroom arm wrestling, but because it is, almost embarrassingly, the most accurate description I can give you of what is currently happening inside a federal courthouse in Miami, where the President of the United States has, at last count, 3 active lawsuits running at the same time, in front of 3 different judges, against 3 very different opponents, and is losing to all 3 in slightly different ways, while describing each loss, publicly, as a kind of victory. So let's actually walk through what's happening, because the headlines have been doing this story a disservice, chopping it into 3 separate unrelated news items when it is actually one story told 3 times, with the same ending each time. And the ending every time is that Donald Trump's own legal strategy keeps handing his opponents the exact argument they needed to win. Here's the setup, and it matters more than it sounds like it does. All 3 of these cases are sitting in the Southern District of Florida, the federal courthouse in Miami. 2 of them, the BBC case and the Capital One case, are in front of Judge Roy Altman. The 3rd, the Wall Street Journal case, is in front of Judge Darren Gales, just down the hall. Now there is another courthouse available to Trump's lawyers further north in the same district, in Fort Pierce, where there happens to be exactly 1 judge sitting. A judge who has, in Trump's other legal matters, been famously accommodating to him. You would think, if you were building billion-dollar cases and you had the choice of courthouse, you'd send every single one of them up to Fort Pierce. They are not doing that. And I think the reason they're not doing that tells you almost everything you need to know about what these lawsuits actually are, because it suggests that even Trump's own legal team understands the difference between a case you might actually want a friendly judge to rule on and a case you're filing for entirely different reasons. We'll come back to that. Let's start with the BBC because this is the one that's gotten the most attention and also the one where the most recent development is, I think, being wildly misreported by people who are moving faster than they're reading. Back in December, Trump filed a defamation suit against the BBC over an editing decision in a documentary, a panorama episode that spliced together 2 parts of his January 6th speech, delivered almost an hour apart, in a way that made it look like one continuous statement. The BBC has admitted the edit was a mistake. Its director general resigned over it. Its head of news resigned over it. Nobody is arguing the edit was good editorial practice. What's being argued is whether it's $10 billion worth of bad editorial practice, and whether Trump, of all possible plaintiffs, has a reputation left that a 2-minute clip could meaningfully damage. Because here is the actual legal problem sitting underneath this case, and it's one that I don't think gets said out loud enough. To win a defamation case, you need 2 things. The statement has to be false, and you need a reputation that's capable of being harmed by it. And Trump's own record around January 6th, the Congressional Committee's report, 8 days of televised hearings, testimony from members of his own party, a federal indictment, his own public statements before, during, and after, all of that already exists. It was already public. The documentary didn't invent a reputation for him around that day. It's arguing about the editing of 2 minutes on top of a mountain of pre-existing, self-authored material. Now, in early August of this year, Judge Altman did hand Trump a procedural win, letting him file an amended, narrower complaint. But here's the part that got flattened into a triumphant headline. Trump narrowed the complaint specifically to avoid having to hand over his trust's full financial records, records a magistrate judge had already ruled were relevant to the case. In other words, to win a small procedural fight about not showing his homework, Trump had to publicly, on the record, shrink the size of the claim he's making. The court has since scheduled the actual trial for February of 2027, so we are a long way from a verdict, but the shape of the fight has already changed, and not in the direction anyone reported it. Move down the hall to Judge Gales and the Wall Street Journal case. and this one's arguably the cleanest example of the pattern. Trump sued the Journal and Rupert Murdoch last July over a story reporting on a letter. A sexually suggestive note, the paper said, carried Trump's signature, included in a birthday album assembled for Jeffrey Epstein's 50th birthday. Trump denied writing it, called it fake, called Murdoch personally, apparently, to say so. And here's the thing about defamation law that I think a lot of casual coverage glosses over because it's slightly technical, and slightly technical things don't make good 60-second clips. If you're a public figure, and Trump is definitionally about as public a figure as exists, it is not enough to say a story about you is false. You have to show the outlet published it with actual malice, meaning they knew it was false, or they recklessly disregarded very obvious signs that it was false. In April, Judge Gales dismissed the case, and I want to read you the actual finding because it's blunter than judges usually allow themselves to be. He wrote that the complaint comes nowhere close to that legal standard. Not close. Not almost there. Nowhere close. And part of his reasoning was almost embarrassingly simple. The Journal's reporters called Trump for comment before they published, and printed his denial in the piece, which means readers got both sides and were left to draw their own conclusions, which is, when you strip away all the legal language, more or less the entire definition of responsible journalism. You cannot simultaneously argue a newspaper defamed you and point to the fact that they included your denial as proof of their bad faith. That's not how any of this works. Gales gave Trump a window to refile an amended complaint, which, knowing this pattern by now, you can probably guess what happened next. And then there's Capital One, which is, I think, the most quietly devastating of the three, because this one isn't really about defamation at all. This is about money and reputational damage in the other direction. Trump's businesses, the Trump Organization, several of his sons, a network of entities, had somewhere north of 300 accounts with Capital One, going back more than a decade. In 2021, months after January 6th, the bank closed them. Trump's team has spent years calling this woke debanking, the idea that banks were purging conservative clients for political reasons, punishing them for the optics of the moment. It's become a broader talking point across the conservative movement, enough that Trump signed an executive order about it, enough that he's separately suing J.P. Morgan Chase over the same theory. But here's what changed at the start of this month. Capital One filed its response, and instead of just saying, "No, that's not why we did it," the bank went considerably further. It told the court, on the record, in a public filing, that the accounts were closed after a months-long internal review by its anti-money-laundering compliance team, the specific department that exists to flag transaction patterns tied to financial crime and terrorism financing. To be extremely precise here, because precision matters in a case like this, Capital One did not accuse the Trump Organization of committing money laundering. It said its compliance team flagged patterns that triggered a review under the same Bank Secrecy Act and anti-money laundering framework every regulated bank in the country operates under, and the accounts were closed as a result of that internal process. That is a very different story than "we didn't like the politics." And once that's the story sitting in a public court filing, the case stops being a fight about political discrimination and starts being a fight about whether a jury believes a federally regulated bank's own compliance findings, or believes they were, in the bank's own filing's words, pretextual. You can guess which one is the harder sell in front of 12 random Floridians. So here's the actual pattern, laid out plainly, because I think it's more interesting than any one of these cases individually. 3 lawsuits, 3 different opponents, a foreign broadcaster, an American newspaper, a national bank. 3 different legal theories: defamation, defamation, and discriminatory debanking. And in every single one, the same structural problem keeps showing up. The plaintiff's own public record, his own past statements, his own prior conduct becomes the strongest piece of evidence for the other side. You cannot sue someone for saying you might be a security risk around January 6th when a congressional committee already built the public record establishing exactly that, in exhaustive, bipartisan, videotaped detail. You cannot sue a newspaper for defamation when their own reporting shows they gave you the chance to deny the story and printed the denial. And you cannot easily win a debanking case built on the claim of political persecution when the bank's own compliance department can point to a documented internal review process that has nothing to do with anyone's political opinions. Every one of these cases was filed as offense. Every one of these cases has, so far, forced Trump's side into defense, narrowing claims, hiding financial records, refiling complaints, walking back arguments. Now, why does any of this matter beyond the courtroom? Because I don't think this is really a story about legal strategy at all. I think it's a story about what these lawsuits are for. When you file a $10 billion suit against a broadcaster over a documentary that most Americans have never heard of and will never watch, you are not primarily trying to collect $10 billion. You are generating a news cycle that centers your grievance instead of whatever else happened that week. You are signaling to a foreign press outlet and to every domestic outlet watching that critical coverage carries a legal cost, even if the case ultimately fails. That's the actual mechanism here, and it's one that doesn't require winning to work. A lawsuit that gets dismissed in April still cost the Wall Street Journal months of legal fees and depositions before it was dismissed. A lawsuit against the BBC that goes to trial in 2027 keeps a foreign broadcaster tied up in an American courtroom for over a year, regardless of the eventual verdict. The pressure is the point, not the payout. And that has consequences for the country that go well past these three specific defendants, because every outlet watching this pattern is making a calculation, quietly, about what stories are worth the legal exposure. And that calculation happens long before any of it becomes visible to you as a viewer. You don't see the story that didn't get published. You only see the ones that did. And on the banking side, the consequences run in a slightly different but related direction. Executive orders and lawsuits pushing banks toward the idea that closing an account for compliance reasons might expose them to a billion-dollar political discrimination suit creates a genuinely uncomfortable incentive. Either banks get more cautious about enforcing anti-money-laundering rules against politically connected clients, which is exactly the kind of selective enforcement the Bank Secrecy Act exists to prevent, or banks get dragged into years of expensive litigation every time a compliance decision touches a powerful person, which raises the cost of compliance for absolutely everyone, and eventually gets passed down to ordinary customers in the form of fees and delays and more conservative account decisions across the board. Neither outcome is good for the financial system. Both outcomes are a direct result of using the courts as leverage rather than as an actual dispute resolution mechanism. And then there's the part that I think gets the least attention of all, which is the sheer volume of federal judicial time 3 lawsuits like this consume at a moment when, and I say this as someone who tries not to editorialize about outcomes I can't yet see, the federal courts are functioning as close to the only remaining institutional check on a lot of what this administration is doing, given a Congress that has shown limited appetite to act as one. Every hour of docket time spent on a defamation suit against a broadcaster from a channel most Americans couldn't find on their remote is an hour not spent on something else. That's not a conspiracy. That's just arithmetic. And it's arithmetic that compounds when you're running 3 of these simultaneously in the same courthouse, in front of judges who now have to manage a caseload shaped, in part, by a plaintiff who appears to be litigating for headlines as much as for verdicts. So, where does this actually go? Honestly, and I mean this, not as a hedge, but as the actual state of things as I record this, some of it resolves in ways that look like wins for Trump, at least on paper. The BBC case narrowed in his favor procedurally, even as the underlying claim got structurally weaker. The Wall Street Journal case will probably get refiled, dismissed again, refiled again, in a cycle that costs the paper money and buys Trump news cycles without ever needing to reach a jury. And the Capital One case will likely turn into a battle of dueling experts about what pretextual means in a compliance filing, which is the kind of fight that takes years, not months. None of these are going to end with a dramatic gavel-bang moment that settles the argument for either side. What they will do, cumulatively, is establish a body of federal case law, created, ironically, by the plaintiff's own litigation strategy, CRS, that makes it measurably harder for the next politically powerful figure to bring the same kind of case successfully. Every ruling against Trump in these cases becomes precedent. Every dismissed complaint becomes a citation in the next media company's motion to dismiss. Trump is, in a very real sense, currently spending enormous amounts of money and political capital building the legal wall that will make lawsuits like his own harder to win in the future, which is, if you sit with it for a second, a genuinely remarkable thing for a man who has spent 40 years suing people to have accidentally engineered. So, that's it. That's the arm wrestling match. 3 tables, 3 opponents, 1 guy insisting each loss was actually a technicality, and a stack of court filings that, read in order, tell a much less flattering story than the headlines that summarize them. I'm Marcus Fenn. This is Borderlines. If you want the version of this story that exists underneath the version everyone else is telling you, you know where to find us. And honestly, given how these 3 cases are going, we're probably going to need a 4th episode before the year's out.